Yikes.
Hey, Boston, both inside and outside Route 128, thank you for coming tonight. Chapel Hill, thank you for coming.
Tar Heels.
Do they know you guys? Do you know these are just criminal defense lawyers? It's not John Mayer performing tonight.
It's certainly not.
Welcome, guys. It's great to see you both. And by the way, I know that I have two different socks on. There's no need to whisper to your neighbor. It's a long story. You know, before we get started, if we can, before I get to these guys, which is why you're here, can people raise their hands so we get a sense of the audience, a luxury they don't really have when they have a jury? How many of you agreed with the verdict in the Steven Avery case? Raise your hand if you agreed. Well, the second one, not the original one. So we have two or three people with the courage, and thank you for that. How many of you have doubts about the verdict, even if you don't disagree with it? That's a significant number. Okay, and the rest. And how about in Brendan's case? How many of you think the right verdict was achieved in that case? Essentially nobody in the room, so it gives us a little bit of a sense. Gentlemen, thank you for coming by. I really am as excited as they are, I should say.
Good.
Obviously, everybody here knows that you believe, as does the vast majority of the audience, that Steven Avery was not guilty. The prosecutor didn't meet their burden of proof. But not guilty doesn't mean innocent. Starting with you, Dean. Do you believe Steven Avery is innocent of this crime?
You know, it's the wrong question. I mean, I hate to duck it, but in the end, what I believe really doesn't matter. I have a belief, and you would guess correctly that I have a strong suspicion that he's innocent, but it doesn't matter what I think. I'm an advocate. I would expect to be biased. And you know, that question, is he innocent or is he guilty, is to my mind, that's a great question for St. Peter someday, a long time for now. But down here on scruffy, messy, uncertain planet Earth, we do well just to say, was it proven or not proven beyond a reasonable doubt? I don't think this one was proven beyond a reasonable doubt, and it sticks hard with me for that reason.
St. Peter, do you want to answer the question or no? I guess not.
I'm not St. Peter, so I guess no. You know, it's Dean's answer is right. Neither one of us were there. It's really between God and Steven Avery, and you know, no one else knows. But you know, when we looked at the evidence as a whole, it clearly didn't add up to guilt beyond a reasonable doubt. And so, you know, I can tell you my personal belief. It doesn't mean much. I think he is innocent. But you know, take it for what it's worth.
Thank you, Pete. Obviously, the central theme here was police misconduct. No surprise to anybody in the room. But the sense I got from both of you is you felt that, and I'll put words in your mouth and then you'll take them out, is that they wanted Avery to be guilty, they believed Avery was guilty, and they just figure a means to that desirable end is perfectly okay. So Dean, with you, you have no belief that either of these two dirty cops had anything to do with the underlying crime itself in any fashion. All they did was, when it came to their attention, thought it was a convenient way to put Avery back in the can. Is that where you are?
Yeah, that's really my view. I have never suggested or believed that the police killed Teresa Halbach or had anything to do with killing Teresa Halbach. You know, once she turned up missing, and then eventually, you know, evidence that she was killed showed up at that salvage yard, I do think very quickly the police focused really exclusively on Steven Avery.
Jerry, was there any piece of you that ever thought that one of these guys may have had some involvement, even for a minute?
You know, maybe when the sheriff says on TV that it would have been easier to eliminate Steven Avery than to frame him, I have some suspicions of that guy. But he wasn't even one of the ones that we could point the finger at. One of the things that really I don't think is clear in the documentary, the judge not only precluded us from telling the jury other suspects that we thought may have done the crime, he also limited us to the number of police that we think were involved in potentially tampering with the evidence, right? You know, it was Link and Colburn. Nobody else we could even, suggest was involved. What that did was it allowed the prosecutor to argue, well, they must be telling you that the police killed her and burned her body, because who else? You didn't hear anything else, and so, he got up in his closing and continued to make that argument, even though we had said that is not our argument. But it left us vulnerable and unable to respond with who we really thought might have been the suspect.
I don't mean to lighten this up, but I had one of these moments that I bet you some of you, as you were speaking, I said, oh my God, that's Jerry Buting and Dean Strang. I forgot we were doing it. It's just.
Nope. Nobody's ever thought that was so exciting.
Well, no, I think there are a few people who think it's, you raised something. Let's get right to that right away. By the way, you guys didn't sign this. I'm not being disrespectful. Very few of them have a name on it, and I'm sorry we didn't ask you to do it. What was the judge's rationale off what you just said for ruling you couldn't bring up other suspects at trial, and how does that not violate Stephen's constitutional right to put on a defense? Since you raised it, Jerry, why don't you respond to it first?
Well, we argued just that it did deny him his right to present his constitutional right to present a defense, because there is a rule in most states, including Wisconsin, that in order to not distract a jury and with nothing but a smoke screen of pointing the finger at some other suspect, you have to have some level of evidence, that what's called the legitimate tendency test most often. And
what does that mean?
well, you have to be able to show that there, another suspect had access, had opportunity, some, tendency towards the crime, perhaps because of their prior record. So, for instance, if you want to argue that the victim's business partner killed the victim, not your client, and there's proof that the business partner was out of the country at the time, and there's nothing to indicate that he hired anybody, then that wouldn't meet the test. And one of the other the cases talk about whether or not the third party has a motive as well. But in our case, at least in our state, it had not been required that a defendant would have to prove access, opportunity, legitimate tendency to the crime, and motive in order to be able to use a third party defense until this case. And the judge said that we had to do that. We argued how not only unconstitutional it was, but how unfair, because in Wisconsin and most states, the prosecution does not ever have to prove the defendant's motive. They just have to prove he intended to kill, not why. And so to say that when we don't even have a burden in a criminal case, the prosecution has that burden, to say that the defense now has to prove what the person's motive was before you can introduce them evidence to a third party was so unfair. And it left us open to the kinds of things that we talked about a moment ago.
Well, the natural follow. Go ahead. I'm sorry.
I mean, to be fair, Jerry's right that one reason for screening when the defense can name names, offer a specific alternate perpetrator, part of the reason for that screen surely is that there's an interest in not, distracting or confusing the jury. There is something more, to be fair, okay? When an accused is allowed to name someone else as the potential perpetrator of a crime, there's a real reputational interest of that other person that courts rightly have to consider. I mean, that other person hasn't been charged, isn't going to be able to come into court to defend himself, and may have his name splashed all over the television or the newspapers or blogs as, hey, he may have committed a murder or whatever the crime is.
But did you have an opportunity to have a hearing outside the hearing of the jury where you could say, we think we have satisfied some of these criteria?
We submitted that all in writing at great length, actually, and laid out the case against a number of potential third-party culprits. And, so, I mean, I want to make sure people understand there are substantial interests to be balanced here on both sides. The problem in the end with the resolution the Wisconsin courts have come to, which is an asymmetry. Defense has to prove motive, but the prosecution doesn't, even though it ultimately bears the burden of proving guilt. The problem with that asymmetry in a murder case is that it makes the admissibility of a third-party culprit for an innocent accused turn on the utter accident of the character of the victim. So in other words, if the victim is a blameless person, as Teresa Halbach was, nobody on the face of the earth would have had a reason to want to kill Teresa Halbach. Nobody. Nobody could have had a motive to do that. And therefore, if you have to show motive, you can never meet your burden and you can never offer the alternate suspect. If, in another case, the victim happens to be someone who all kinds of people would have had reason to want dead, you know, he was a drug dealer who didn't pay his suppliers or who cheated his buyers or you know, a cheating spouse or, you know, whatever, somebody who didn't pay gambling debts. Now, the innocent accused will be able to point to alternate suspects. And the problem is that the accident of the victim's character has absolutely nothing to do with the potential innocence of the person charged.